Hi everyone. I'm just going to wait another couple of minutes before we start the legal seminar. I know some people have signed in already, but we're waiting on a few more. So we'll probably start in about 3 or 4 minutes, and we'll kick off pretty promptly then. Thanks. Good afternoon, everyone, and welcome to the Children's Rights Alliance's legal seminar on a child's right to education. For those of you who don't know me, my name is Saoirse Brady. I'm Head of Legal Policy and Public Affairs with the Children's Rights Alliance. Many of you will know the Alliance organisation. We unite over 100 members to make Ireland one of the best places in the world to be a child. So I'd say that there's been huge interest in the seminar, and we really welcome you all taking time out of your busy. I think it's very telling and very timely that this seminar is happening today. We've got two excellent speakers that I will hand over to in a few minutes. But first, I just kind of want to give you a bit of context and background to why we're having this event today. For the Children's Rights Alliance, like many other organisations, huge last year focused on the impact of COVID-19 on our children and young people. And unfortunately, that has continued into this year, particularly because of the school closures. You know, we're a year now since the first lockdown, since the schools first closed. And last year, our children had many months where they weren't physically in school. That's despite health advice that says that schools are safe places for children and young people. And that's really down to a lot of the work that's been done by educators, schools, principals, to make sure that those schools stay safe places. year, children and young people haven't been in school at all. And we've been hearing from our kind of impacts that that has had on our children and young people. It's affected all children and young people with their well-being, their mental health, and the relationships that they have both with their peers and the educators. It's had a particularly detrimental impact on certain focuses of today's discussion. So children with special educational needs and disabilities, we've heard from our members about how they're starting to regress, how they have regressed over the last year. The behaviour that they're starting to display, that's a real concern for their parents and those who care for them. About child welfare and child protection concerns, because many children aren't in school. And school is usually the place where teachers and those working very closely with children will usually work out that there's something wrong at home and that maybe some intervention is necessary, and they get the family and the child that way. And that is. We did launch a campaign, the Children's Futures campaign, and we've done that with a number of our members initially. So that would be As I Am, Inclusion Ireland, and the National Parents Council Primary. And we have a number of asks, and we are happy to hear that there have been some announcements this week by government that will move on some of those asks. But I suppose the things that we're calling for include immediately reopening all special schools, public health advice. At the moment, they're only open at half capacity, and we think they should be open fully for those children who really do need that support. We're asking for all schools to reopen in line with public health advice, and we really want to make sure that schools stay open once they do open. And we are glad that government is prioritising the opening of schools. We've heard that time and again, but we need to make sure it happens. And that's what the campaign is all about. We also think that government and the departments need to provide interventions to the learning loss that's occurred for children and young people over the last 12 months. And clarification around real concern for young people. So we need to ensure that they do get confirmation next week of what will happen for them. But I think that will make a real difference for those young people and hopefully take away anxiety that they're feeling around the exam. And then finally, we want to ensure that the best interests of children are central to decision making, that there's a whole of government approach to addressing the impact of COVID-19 on our children. And this year marks a real opportunity because we will be updating the national strategy for children and young people, and that really needs to be a recovery strategy. We really need to think about how COVID has impacted all aspects of life. It's a real opportunity to reform the area of education in particular. So as I mentioned, we launched the campaign this week with some of our members, but we have put a call out to all of and we've heard back from some of them who do want to lend public support to that campaign. So we'd love to hear from any of you who haven't already been in touch with us about it. And you know, if you aren't already a member and would like to become a member, whether you're an organisation or an individual, please do get in touch as well. There are details about how to get involved on our website, childrensrights.ie. So we'll be recording this session and we'll also be tweeting about it. So if you want to follow the conversation, you can on the hashtag Children's Futures IRL. And question Q&A, those won't be publicly displayed, but we and hopefully through as many questions as possible with the speakers. So if you could identify if you're from an organisation, please, and keep your question as short as possible so we can get through as many as we can within the time. So that's all really from me, except to introduce the speakers that we have this week. So we have James Rooney, who's a practicing barrister specialising in human rights. And James recently completed a PhD in socioeconomic rights at Trinity Law School, where he teaches constitutional law. And we also have his colleague, DP Brady, who's a practicing barrister, also specialising in human Trinity Law School. So we're going to hear from them really on the legal opinion that they've provided to us, on which we based some of our campaign calls. And they're going to look at the constitutional aspects of it, and then follow that with the international law aspects of it as well. So please do feel free to ask questions, and we hope that you can stay for the rest of the webinar. It'll take about 30 minutes to go through the presentations, then Q&A, so we hope to wrap up by 2. Thanks. James, can I hand over to you now? Yeah, thanks.
Yep. Thank you very much, Saoirse, and hello everyone. My name is James Rooney, and I will be providing the commentary on the constitutional right to education in this, and then my colleague Alan will be talking about the international rights dimensions to the right to education. So our constitution in Article 42 states, among other things, that the state shall provide for free primary education. And this has been interpreted by the courts a couple of times over particularly the last 40 or so years. The first 40 years was very little discussion about what free primary education, the provision for free primary education means. However, it has been interpreted by the courts to mean not a duty on the state to provide primary education itself, but to create the infrastructure whereby third parties, for instance, may be able to provide for a free primary education. So in a case from the 1980s called the Crowley case, which is mentioned in the opinion, there was a strike in a school in County Cork, and for 2 years children were not able to access an education. The parents of those children sued the state and said that the state was violating its right to provide for free primary education to the children. And the Supreme Court ultimately decided that the extent of the state's duty is to create a system whereby a free primary education can be provided, and provided that the schools are set up and there is payment for teachers and there is curriculums arranged, then the responsibility for education does not lie on the state, but rather on the particular educators, in this case, the teachers and the organisation which was striking in that case. So since then, the right to education in Ireland has been interpreted such that if there is provision made by the state for whereby children can access an education, that will often satisfy the requirements of Article 42.4. The question then becomes what constitutes an education, and this will vary depending on the particular circumstances of the children involved. So it has been in the area of children with special educational needs that there has been particular use of the right to provide for free primary education, because with children with special educational needs, the provision in a mainstream school of a mainstream education is not always properly suited for children with such needs. So in a case from the 1990s called O'Donoghue, a child with autism was not being educated whatsoever by the state, and there was his parents sued on his behalf, saying that the state was failing to provide this child with a primary education. And what was decided by the court was that education for the purposes of this right means whatever training or instruction is necessary in order to make a child able to use, make the most of their inherent and potential capacities. So however limited those capacities may or may not be. So it suggests that the right to free primary education should be somewhat tailored to the degree of capacities or capabilities of particular children. The court in the O'Donoghue case also held, as there was no provision whatsoever for the education of Paul O'Donoghue, the child with autism in that case, that the state was in default of its obligations. So provided that no education is being provided which would enable the child to make the best possible use of their capacities, then there would be a breach of Article 42 of the Constitution. And further, in the Supreme Court in that O'Donoghue case, the Supreme Court held that this appears to impose a positive obligation on the state to provide for a free primary education where none is being otherwise provided. Now, in that case, the Minister for Education provided the child with placement and with education prior to the deciding of the case in the Supreme Court, so no actual positive order needed to be issued, but it nevertheless shows that the right under Article 42 is one which can impose a positive duty on the state where zero provision for education is otherwise being provided, which perhaps in the present context, perhaps could be relevant in cases of, for instance, children with special educational needs, whereby an education through remote learning is not a possible way which they're able to actually make the best use of their inherent capacities, or indeed also children who don't have access or reliable access to online learning or to sort of reliable internet by which they could gain an education currently, might be examples of groups of children who the current remote learning approach would not satisfy that requirement of providing some form of education. After Donoghue, there is only a very few amount of sort of significant cases in this area, one of which I suppose is relevant to the work of the Children's Rights Alliance, is that these rights to education, the duty on the state to provide for an education for children with special educational needs, goes up only to the age of 18, so only to the age of majority, and therefore is unusual in the Irish constitutional context as a right which is particular to children. And most recently, the sort of most recent nuance to the court's reasoning in regards the right to provide for free primary education, involving, again, this case also involving children with special needs, is a case called OC and Ireland, which is from the first decade of the 21st century, from I think 2007. And in that case, the parents of the child OC wanted their child, who also had autism as well as the O'Donoghue child, to access a particular kind of ABA autism treatment, and that wasn't being provided by the state. And so they sued, saying that the provision by the state of education for their child wasn't sufficient. And what the court decided in that case was that provided that the educational provision for the child by the state was reasonable, not necessarily means that doesn't mean the best education necessarily, it just means a reasonable standard of education which could reasonably be expected to assist the child to make the best use of their capacities, then the test from O'Donoghue will be satisfied. What this means is that where the state is providing zero education for a child, irrespective of the needs of the child, then they will be in breach of Article 42.4. But when there is some educational provision being provided, the question becomes whether or not the degree of educational provision is reasonable or not. And determining what education means in these instances goes to the degree to which the provided education is able to help the children involved make the best use of their capacities. So in as much as children have a spectrum of inherent and educational capacities, the duty on the state is to ensure that across the broad spectrum there is a there is education provided for children across the spectrum of educational need and capacity. And in as much as the current remote learning approach to the education of children doesn't necessarily fit all the educational needs of all children, and as the Children's Rights Alliance, as Saoirse mentioned in the correspondence for this, that there's been children who are perhaps progressing since the move to remote learning and who would be in need of special educational schools in particular in order to enable them to make the best possible use of their inherent capacities. It is arguable, and this is something which Alan and I discussed in our opinion for the Children's Rights Alliance, that the current approach is contrary to the provisions of the Irish Constitution. This is, of course, we're in a the coronavirus pandemic is, of course, a emergency which the state hasn't had to grapple with, certainly since 1937, when it drafted into our constitution rights to education and the right to free primary education for all children. However, it also is the case that the current emergency cannot set the rights which are in our constitution at naught, and so it can't be used as a justification for enabling children who are in need of an education, who cannot receive it at home, to go without, and to sacrifice the rights which are protected under our constitution for the emergency seems quite a I think we'd all agree sounds quite a scary and precarious idea. And so whilst it is very important to act carefully in this pandemic, given that there are options out there which are clear in other countries whereby children, particularly children with special educational needs, are able to be educated in secure educational facilities, and therefore avoid the risk of regression and enable them to actually get an education, a meaningful education, then that is perhaps a approach which would be more consistent with the obligations which the state is under Article 42 of our constitution. This is something which I'm happy to take as many questions as possible at the end, but for now I'll pass over to Alan, and he will talk about the international rights context in regards to the right to education. Thank you.
Thank you very much, James, and thanks very much to Saoirse and everybody at the Children's Rights Alliance for inviting us first to make a contribution on the legal issues, and also to address all of you here today in the virtual congregation. You will forgive me forever using my middle initials in every situation I find myself in professionally. I don't do it because I'm pompous, although I assure you I obviously am pompous being a barrister, but I don't want to be confused for the other Alan Brady, who is a construction law expert, and I'm fine with that. I want to, I suppose, focus primarily in what I have to say this afternoon, particularly in light of the time available, on the European Convention on Human Rights. The UN Convention on the Rights of the Child does also address the right to education, but I think the ECHR is of more significance here in circumstances where it has a direct effect internally within the Irish state. The reason it does is because of the European Convention of Human Rights Act of 2003, which requires that organs of the state will perform their functions in a manner compatible with the state's obligations under that. And certainly the Department of Education, HSE, the Department of Health, and so on, are all organs of the state within the meaning of that term. There is also an obligation under Section 42 of the Irish Human Rights and Equality Commission Act of 2014 that obliges public sector bodies to have regard to the need to protect human rights of the persons to whom they provide services. So there's clear statutory obligations on all of the relevant players in this to conduct their functions in a manner that is compatible with the ECHR. And I suppose, unlike the UN Convention on the Rights of the Child, which isn't directly effective internally in the state, it's an obligation between nations internationally, if I put it like that. It doesn't necessarily have as much immediate force. And there is some interesting jurisprudence, or sorry, case law from the ECHR, which I think is of significance here as well. The ECHR itself does not contain in the main body of it a right to education. It is contained in the first protocol to the ECHR, which was adopted, ratified by Ireland at the same time that we adopted the ECHR in 1953 and came into force in 1954. It's also covered by the ECHR Act of 2003. And the Article 2 of Protocol 1 specifically protects a right whereby no person is to be denied the right to education. So it is an obligation on the state not to deny you an education. And that's a very significant distinction. As James was very helpfully setting out, the Irish constitutional right involves a positive obligation on the state to provide for an education, to put in place the architecture and the infrastructure that will ensure that the right to education can be realised. Whereas the ECHR right is a right not to be denied education. So it effectively means that the state can't stop people from getting an education in whatever institutions exist in the state at a given time, but does not appear to involve an obligation to provide an education. Much of the case law from the European Court of Human Rights on this specific right relates to language rights. But there is a clear line on how this right is to function. And I suppose in order to elaborate on that, I just want to mention two cases from the European Court of Human Rights that I think help us to understand how this right works. The first is a case called Katan and Moldova and Russia, which is a decision of the Grand Chamber of the European Court of Human Rights from October of 2012. The value of this case is that it really emphasizes and pulls together the case law on the question of proportionality. And I'm going to elaborate on what I mean by that a bit more in a moment. But just to explain the background to the case, there was a region of Moldova that was essentially a contested geographical area, a separatist movement in Transnistria, and there was an obligation, a law passed by the initial separatist state, requiring that Moldovan, the language of Moldovan, would be taught using the Cyrillic alphabet, which is the alphabet that is used for Russian and various other European languages. But commonly, many Moldovans use the Latin alphabet, the alphabet we use for English, French, Spanish, and so on. And the law required that schools could not teach Moldovan through the Latin alphabet. And if school did, it would be closed. And indeed, there were school closures, and there was, some, obviously it was quite a fraught time, and there was a certain degree of hostility around this. The Grand Chamber of the European Court of Human Rights found that there had been a violation of Article 2, the right to education in Protocol 1 to the ECHR in that case. It found that finding as against Russia for reasons I don't necessarily need to take up your time with now. But in coming to that conclusion, it made a few very important observations about how the right to education in the ECHR functions. So it acknowledged that the right to education will necessarily involve, by its nature, will involve some degree of state regulation. When we say that the state can't deny you an education, it doesn't mean the state can't have any involvement. Obviously, states are involved in the setting of curricula, in many cases they're involved in payment of teachers and so on. So there's no difficulty with that. But a limitation on the right cannot be such that it would impair the very essence of the right and deprive it of its effectiveness. Any limitation must be in pursuit of a legitimate aim. Now, I think I have to acknowledge a massive public health crisis of the nature of the one we're living through at the moment is certainly likely to be found to be a legitimate aim in those circumstances, but there must also be a reasonable relationship of proportionality between whatever measure limiting the right to education is adopted by the state and the aim being pursued. There is a margin of appreciation, so some deference is paid by the European Court of Human Rights, but that margin of appreciation increases as you work your way up the levels of education. So this right, unlike the Irish constitutional right, applies to primary, secondary, and third level education. But the higher up in the level of education a student is, the greater the degree of a margin of appreciation will be afforded to the state. In the context of what we're discussing here, obviously primary schools, there'll be considerably less deference or margin of appreciation afforded. The other case I want to mention is a case called Memlika and Greece, which is a decision from the court from October of 2015. The judgment itself is not available in English, it's available in French, Greek, Icelandic, and another language that escapes me at the moment. But the core analysis of the case is of use in that what it involved was 2 primary school age children who had been misdiagnosed with leprosy. And they were excluded from school for about 6 months, from May, June until December in the year of 2011. And over that time, there was supposed to be a committee established essentially to ascertain whether they could return to school, and there were significant delays with that. The court found that this was a violation, and I think it's indicative in terms of this idea of proportionality that we see from the Katan case, that when we are looking at restrictions on right to education, we are not taking an absolute position when we look at the ECHR. We're not saying that all schools must open regardless of the public health advice. A proportionality test is very fact sensitive. It has to look at the specific evidence on the ground. But what we know is that for some time, the NEFID advice has been that schools themselves are relatively safe environments from a COVID perspective. We also have the experience from September until December of 2020, when schools were open and transmission rates in those schools seemed to be relatively low. Pulling all of that together and thinking in terms of what this means in real terms, when looking at the effect of the ECHR and indeed the constitutional rights that James was outlining a minute ago, we accept that we are in an unprecedented public health crisis, and nobody thinks that this is easy. And I certainly don't doubt the sincerity and the good faith of public officials who are trying to do their best in a crisis. If a case on this issue were ever to make its way to a court and ever to be decided by a court, I don't doubt that the state would respond by saying that the limitations on the education right involved in the school closures that have been in place since the start of January were a justified intrusion on constitutional and European Court of Human Rights, Convention on Human Rights. And it's true that ultimately, if there were a dispute on that, the final arbiter would be a court, and accept that as James has acknowledged, that the public health crisis would no doubt be something that was factored into a court's analysis. The reality is that it is unlikely that we would get a final court decision in any litigation before the schools open in any event anyway. I know that there have been proceedings launched in respect of special schools, but the special schools are opening, albeit at limited capacity at present. But the fact that these rights ultimately would have to be decided upon by a court for a final answer on exactly where the line is to be drawn is not a reason to ignore them at this stage, both in public discourse, but especially in policy making. Fundamental rights under the Constitution of the ECHR, they are not the sole preserve of smart-ass barristers with PhDs like me and James. That's not what they're for. They are for everyone. They are there to protect every individual in this state and every child in this state. They are not suspended in a crisis. If anything, it is in a crisis when they are most needed. And when we look at the approach that is being taken, it is incumbent upon the state to justify these limitations in rights terms. It is not enough to simply say COVID, and that's the end of every discussion. There are very clear rights here, both under the Constitution and under the ECHR. If we have a willing school and willing teachers and a child that wants to attend that school, the state's entitlement to stop that school from going ahead from the point of view of the ECHR is only there if it does so proportionately. And so it needs to justify it in proportionality terms. This is not some fringe viewpoint. These rights are fundamental. They are fundamental to our legal system. This is a nation of laws. Without laws, there would be no constitution, there would be no Oireachtas, there would be no Department of Education, there would be no HSE. All of those things are created by the law, and fundamental rights are the bedrock upon which we have built our legal order. When we speak about a rights-based approach, this is not some recently invented woke phrase. This is, in fact, a fundamental requirement of the legal system that we have. These rights are exceptionally clear in terms of the existing case law. Yes, this is a new situation to which they need to be adapted, but certainly James and I would argue strongly that that needs to be central to the policy making. And if they are going to be intruded upon and limited, that has to be justified in rights terms. I'm very happy to answer any questions that anybody has.
So thanks very much, James and Alan. That was great, a great overview and very concise for two barristers as well, I might add. So thanks for keeping to time. That leaves time for plenty of questions. And we have had some questions in. I'll just say at the outset, though, we can't answer and we can't ask Alan or James to give legal advice on an individual case. And there are a couple of questions there on individual cases. But what I will say is the Children's Rights Alliance has a legal information line, and we do operate some legal advice clinics. So if you could send those through to help@childrensrights.ie, or we do have a phone line. The number is 01902 0494, and we'll put that in the chat function box. You can forward on your individual queries, and we can see what we can do to help you with those. So I won't put those to the barristers today. But and one of the first questions we have is about what about children with additional needs in mainstream class
I'm just going to take over there because I think Saoirse's just having technology issues there. So I might go through, so just for people who are in attendance, I'm Tanya, I'm the Chief Executive of the Children's Rights Alliance. So I might just maybe go through that question there that Saoirse was covering. So I think that as Saoirse said, some of the questions essentially are linked to individual cases, and then some are broader. Saoirse, are you back? Do you want to carry on then? Okay.
Sorry
No
about
problem.
that.
No
my
problem.
my
No
Wi-Fi
problem.
goes in and out.
No problem. Okay.
No worries. So yeah, no, I was just saying, you know, they do very much form a part of the campaign. So I don't know if James or Alan have anything to add on that particular one.
Yeah, I'm happy to. Thanks very much, Saoirse. Yeah, so to the question of children with additional needs in mainstream classes, it's the degree to which they are entitled to an education which enables them to make the best use of their capacities is the same as both the children in those classes which do not require additional needs and those who are having their additional needs cared for in special schools. So in as much as it can be shown that children with additional needs, maybe perhaps without the help of an SNA or without the provision of assistance to enable them to access their education with their particular additional needs, in as much as the absence of those scaffolding and structures been able to enable them to access an education aren't there, then they are as much entitled to provision of those facilities as children in a special school would be as well. So I think the point to be taken that they perhaps are forgotten in the discourse about rights in this instance. Their rights are equal to and must be satisfied in the same way as those children in both special schools and children in mainstream schools who are able to access an education more without additional help.
Okay, thanks, James. Alan, did you want to add on? Or there's a number of other questions here, so I might move on unless you have something pressing to add. Okay, so we have another question in that says, is there a legal requirement around the provision of therapies? These have all but ceased since last March. One-to-one cancelled as deemed not safe. Is there anything on that around the legal therapies?
I suppose it depends. In terms of the right to education specifically, it will be very dependent on the extent to which whatever therapeutic intervention was required to facilitate the education. If it's a child who requires therapy generally because of their level of ability or because of some special need that they have that is unrelated to the right to education, then they're in relation to them receiving education, then the right to education wouldn't necessarily be of much assistance there. But I suppose the thrust of our analysis is that where a child is getting no educational provision at all, that is the circumstance in which the constitutional rights and the ECHR rights seem to be most in jeopardy in these circumstances. So if it was a therapy that was required, that without that the child couldn't access education at all, then that would certainly be something that will give rise to a concern.
Anything to add there, James, or are you happy enough with that?
So
the next question is, can the panel comment on why Ireland has taken such an approach to education, particularly special education during COVID? Are there particular circumstances that caused this? I'm not sure if you do have an answer to that, but is there anything you'd like to say on that?
I suppose in thinking about kind of proportionality analysis, I suppose James and I, when we're litigators and we're legal academics, and that's the expertise that we bring to bear in a situation like this, so we can understand how it would be that these arguments would play out in a court, and that's the particular skill set that we have. I suppose thinking about a proportionality analysis, it requires the state to explain why the limitation is justified, and I suppose the lack of a rights-based prism through which much of the discussions have been taking place has maybe led to that absence. So that's as much as I suppose I could say about that.
Somebody else asked if there were any proceedings, who would be the defendant in the proceedings? Would it be boards of management or the Department of Education? And they've asked that in line with the Louise O'Keefe judgment.
Yeah, that's a good question. So the Minister for Education is the party which is required under the the state is the duty under Article 42.4 to provide for primary education is on the state. So my assumption would be that it would be the Minister for Education, the Attorney General in Ireland, who would be sued for breaching the Constitution if the argument is that they have failed to provide for free primary education. And certainly in previous cases involving children who have been sued to access a free primary education, it has been against the state. So my assumption would be against the state. Whereas in the O'Keefe case, the question was whether or not the state could be held liable for abuse and sexual abuse which occurred in the school context. So it was there was a nuance to that one which I think would be different to these ones, I'd say.
I just add, under Section 7 of the Education Act of 1998, there is an obligation specifically placed on a statutory basis on the minister, and there is some case law to suggest that that statutory mechanism is the way by which the constitutional obligation has been put on a specific state body. That said, if there was a particular intersection of conduct from multiple parties, certainly it's not uncommon for multiple state bodies to be sued simultaneously in respect of the same rights breach. So, it is not unheard of for the Minister for Education and the Board of Management of a specific school to be sued simultaneously in respect of an issue that has arisen in a particular case. But again, that would have to be, we're not in a position to advise on specific cases, but as a general proposition, that is something that can be done.
Okay. Somebody else asked about, it was a follow-on from another question, I think, just around, why special education didn't open during COVID, but they did ask about the balance of rights between children and teachers, and if you had any comments on that.
I mean, sorry, James, excuse me.
Oh, no. I was just going to mention, there's only one case I can think of off the top of my head which deals with the balance of right between children and teachers. The first case to deal with the right to education significantly in Ireland was a case called Crowley. I mentioned the strike in schools in Drumalee, County Cork, and it was, the teachers were organised, and they were members of the INTO, and the question was whether or not the rights under the Constitution to organise in this case under the INTO would be balanced against the rights of the children to receive the education. Now the judgment kind of, there was two judgments in this case, and in one of them the Supreme Court held that the INTO was liable for the days in which the children were not able to access education prior to the resumption of education. So perhaps that suggests that there's a balancing that has to take place there. There are two constitutional rights in play between the teachers' union and the children in a case like that, and that there will be a balancing that would be taken by the court.
I just add, there's no question but the teachers have a right to bodily integrity. They have a right to life. Nobody is suggesting that teachers' rights aren't important here. On the ECHR side, the right not to be denied education presupposes a school that is willing to provide an education. So if you're in circumstances where there is no school that is willing to provide an education, and that is not by virtue of state action, then the ECHR right doesn't really enter into it at all. It's the state is obliged not to interfere with that relationship between child and educational institution in a disproportionate fashion. I would note that at the time of the school closure at the start of January, the justification given wasn't a concern about the health or life of teachers. The justification given was essentially that although schools are safe environments, the mobilization of people involved in getting 1 million children to school every day created a risk of community transmission. So, if there is to be a justification given in terms of teachers' rights, which unquestionably teachers have, and I can't overstate the respect I have for the work that teachers are doing during the pandemic. I have children myself, and I had to very carefully ensure I didn't have a SpongeBob SquarePants background on this afternoon when I logged into Zoom. So, what is going on for children at the moment is not lost on me, and the Trojan work being done by individual teachers is not lost on me either. But when we're looking at the kind of the state level in terms of justifying this type of blanket policy, if there is to be a justification given in terms of teachers' rights, then let that justification be given and let us explore that. And again, I think in circumstances like this, in a crisis like this, as I've said, it is important that the public discourse and the policy language is rights-based and not just treating rights as being something that will be dealt with in a court at some later stage. For them to be meaningful, they have to be given life in that way.
Great. So another question we have is, thankfully SEN is back on Monday. Hopefully all schools will follow in March. once children are back in education, can we start a conversation with the Department of Education regarding school calendar and Easter summer closures? Surely prolonged closures cannot be justified. I'll just say, from a Children's Rights Alliance point of view, we will be entering those discussions, particularly in relation to the national strategy that I mentioned earlier. I think there's a bigger conversation to have here. So certainly we'll be pushing that. I'm not sure that there's anything to add from the legal perspective there. So unless there is, I might move on to the next question.
The obligations of the right to education don't ban school closures at weekends, they don't ban school closures at holidays. So I mean, where you're not obliged to have 365 days a year of school, but I mean, there has to be adequate provision. So I think in terms of the rights, that's where that would fall. Certainly, once we get to the stage where there is actual day-to-day provision being provided, even with school holidays going ahead, I think the risk of an unconstitutionality of the approach is reduced. But I would defer to James on the constitutional point.
No, I would fully agree with Alan on that, and I would mention, I think, as Al mentioned, also there was the Strasbourg case of Memnica, which was raised, which dealt with a prolonged exclusion of children from school on the basis of leprosy, and they've suggested that overly long exclusions might be contrary to the convention, but it comes a sort of a scalar thing of, from the level of, as Al mentioned, like weekdays or weekends and sort of public holidays which we accept schools won't be open, and certainly summer holidays as well, to prolonged closures which at a certain threshold point might cause an issue as far as the convention compatibility or constitutionality goes.
Great. So I'm going to maybe give you a couple of questions together there that might be linked. So what are the rights of children with extra needs in mainstream to get extra help when they return to mainstream school? And that's from Catherine and the Voices of Disabled Children. And another one is, what do you recommend we do from here as a group of parents? Can parents bring a case retrospectively for the time lost and to ensure it doesn't happen again?
James, do you want to take the first part of that and I'll take the second?
So the second part was about the retrospectivity point, and the first part, sorry, Saoirse, if you.
Sorry, it's just disappeared from my screen. The first one was, what can we do when children do get back into mainstream schools? What can be done to ensure that they get the resources that they need and the help that they need?
Yeah, so it's a good question, and I suppose as litigators, Alan and I, the natural recourse that comes to mind is that if you're not receiving the educational provision which you are entitled to, and the mainstream provision of education is not one which is sufficiently tailored to the needs, educational or additional or physical needs of your child, then as they have a right under Article 42, they should be able to sue the state in order to get performance of that positive obligation to provide them with that education. That, of course, is, however, fully accepted, not by any stretch of the imagination the most accessible way by which you're able to ensure that children will be able to receive the kind of care which they need after the resumption of school places, whenever that should happen. But it's certainly the one which comes that I can come to mind.
Just in terms of a retrospective action after the schools are closed, I suppose the Irish legal system is what we call a common law legal system. It's very much based around live disputes, and the courts don't engage in kind of advisory opinions. So if an action was to be brought after the schools had closed, it would need to be an action seeking some specific order. If the school is now open, you're not seeking a court order requiring the school to be opened. It is unlikely a school would give kind of a declaration just for its own sake. So then you're into the territory where someone would need to be essentially bringing an action for damages. I think obviously I can't make any comment about any specific case at all, but I mean, in terms of what an action for damages would be likely to bring at that stage, I don't know how you would necessarily measure quantum, the amount of damages or anything like that. It may be by that stage there's less meat in the legal issue, but in terms of bringing your respective case, you would have to find something that you wanted a court to give you. And I think maybe James might be able to speak to the Crowley case, where there was, I think, 2 years of no schooling, and there was a damages action brought in that case subsequently. But I don't know how far that case would necessarily get. But as I said, I'd I can't make kind of a general comment about a specific case.
Fair enough. There's another one here that is it's from a parent who's very upset by the proposal that only half of primary schools will go back first, because all of her children are in the senior end of primary. So she feels that their rights are being disregarded. Is there anything that can be done there? And I suppose there has been a big focus on children with disabilities and SEN this morning, but another person has asked about DESH schools. You know, we have a system of DESH schools in Ireland. Is there any requirement to get these schools open where children grow up in and are experiencing multiple inequalities, disadvantage and vulnerability? Is there anything that we could say about children other than those who may have SEN or additional needs? Are there any legal arguments that could be put forward in relation to older children perhaps, or in terms of children from disadvantaged areas?
What comes, as far as children from disadvantaged areas, what would come to mind is if the argument could be made that online remote learning was not able to provide a appropriate education for children, perhaps because of lack of access to the internet, or maybe poor connectivity, or a myriad of reasons which would preclude consistent access to education through remote devices, that could, I could see an argument anyway, provide a actionable issue by which you could sue. You could challenge the constitutionality of the provision of education through remote learning. But save for that, I think that's sort of the only hook which I can see come to mind as far as the particular issues of DESH schools would be engaged by the current case law.
On the partial reopening of schools, I suppose, again, coming back to the proportionality point, you know, when the state is limiting the right to education, it is obliged to justify that. It is obliged to have a good reason to do it, and the limitation has to be proportionate. So if it is the case that schools themselves are safe places and can be reopened relatively safely, and the schools reopen on a phased basis over a relatively short period, then one could see how that could be proportionate, because it'll be pretty clear quite quickly whether the school reopening is causing difficulty. But if there is a long and protracted period where only some classes are in and others are not, then it gets much harder for the state to justify that as being proportionate.
Thanks for that. Another two questions that are kind of linked. So is there an entitlement to make the days lost up out of term time? I know you talked about summer holidays already, Alan, but particularly for SEN schools where most children cannot avail of remote learning. And does the panel have any opinion on whether the July provision for children with extra needs is a legal obligation of education by the state, especially given that so much school time has been lost in the past 2 years? The provision is ad hoc at best at the moment. So is there anything on I suppose July provision for children with special educational needs, or you know, making up lost time during summer holidays for all children? Is there anything from the legal perspective there that could be useful for people?
I suppose from the ECHR point of view, because it's a negative right that prevents the state from stopping you attending a school that wants to open. If there's no school that wants to open in July, then the ECHR right doesn't really enter into it. I suppose on the provide for education side, it's the Irish Constitution that places a positive obligation there. It seems to me like a relatively marginal case in terms of constitutional terms. Like, once the schools are back open, having them open for longer to make up for lost time, I think to succeed on that argument, you would need to show, you know, that there had been a very, very significant restriction of the child's capacity to engage with education that needed to be made up immediately. I'd sort of defer a bit to James on that point, but I see him nodding, so I think he accepts.
Yes. Yeah, it's, I mean, as I think Alan would agree, these are just the uncharted territory, which is the coronavirus pandemic. Even 1 year in means that sort of making extrapolations from the existing case law is sometimes, you know, it requires sometimes just to sort of think beyond what we would know for certain. But I can imagine something like what Alan said, that if it could be demonstrated that there was regression through the absence of education in the past, because of not being able to enter a special school or receive additional education in a mainstream school, then perhaps that could be perhaps that is one of the only instances I could really imagine. And even then, I'm sort of not 100% confident on its possible success rate, that you could challenge the need to open schools into the future when they can be resumed. Summer.
I just add on that point, I suppose in my experience, in circumstances like that, if, again, speaking hypothetically, if a case of that type were to be brought, I suppose it's often very frustrating for parents when they find themselves in litigation and they have the evidence of their own eyes of the child that is in their house 24 hours a day that they see all the time. And the court says, well, I need to hear from an expert. Opinion evidence can only be given by experts under the Irish laws of evidence. So in terms of establishing that in a specific case, I don't think the case would get that far unless there was a report from a psychologist, from a psychiatrist, from a speech and language therapist, whoever it might be, to establish that there was a specific need to have that education made up. So I think as far as the constitutional rights are concerned, and I don't know that there's a mandate for mass continuation of school through the summer holidays. But that is not to say that on the specifics of a particular case it couldn't happen, nor is it to say that it's not a good idea. But in terms of a constitutional mandate for it, I think that's a separate thing.
Okay, we're coming up on 2 o'clock, so I'll give you 2 quick questions to finish off with, and I'm sorry that we didn't get through them all. There's been huge interest and lots of questions there. If you do have individual questions relating to individual cases, do get in touch with us at the Children's Rights Alliance at help@childrensrights.ie. But there's a question from Inclusion Ireland. Can the panel comment on the impact of potentially successful cases currently before the court? I don't think they're asking you to comment on the case, but would the judgment pertain to the individual child or all children? And a final question is there merit in taking cases to the Ombudsman for Children rather than through the courts? Would that be useful?
I suppose go ahead, James, sorry.
No, sorry, I didn't mean to cut across you, Alan. On the point about whether the judgment would apply to the individual child or to all children, whilst the judgment would be pertaining to whilst the applicant of the judgment would be the particular child involved, the judgment would be a broad duty upon the state to provide for an education for children more generally, so that other children and other children's parents or guardians who are in a similar situation to that of the child who was the applicant would be entitled to the same sort of treatment as the applicant in a case like that would receive.
Just to add to that, I mean, that's in the circumstances where a case gets to a full judgment. I think one thing that is often missed in this area of law is the number of cases where cases are started and then an agreement is reached with the state to vindicate whatever the specific rights breach was without the case having to go on for a full hearing. And I think that's important because in those circumstances, there is no judgment, there is no clarification of some specific point of law with general application. But certainly as a lawyer, if you are acting for a specific child, your fundamental duty ethically is to that child. So if you've brought a case to get services or education for a child, and that child is then offered those education or services, your obligation is to try and make sure that offer is taken as quickly as possible and the child gets what they need, rather than seeking to push the case on for a hearing to get a judgment that might have wider application. And so there is a kind of a space around big constitutional rights judgments where policy and decision making is affected by it, and even litigation is brought without necessarily coming to a conclusion with a final judgment. Sorry, I've forgotten what the second part of the question was, Saoirse.
The second one was about would there be benefit taking cases to the Ombudsman for Children rather than through the courts?
Certainly, I mean, the OCO it's a very important part of our rights protection mechanism in Ireland. And although it doesn't lead to specific court orders, the problem we were just describing in terms of once you get an offer of a school place, the case is over, that doesn't necessarily follow with the Ombudsman for Children's Office. And so they can engage in detailed investigations and they can produce reports, and there's a kind of a wide range of powers that they have. Similarly, there's significant powers that the Irish Human Rights and Equality Commission has that are of value. And I think when I said earlier on that that human rights and constitutional rights are not just for smart arse barristers to go into court with, like they are they are part of the fabric of our state. And the more mechanisms we have for keeping them at the center of how we think about children's needs, the better.
Great. Well, thanks so much. I'm going to close it off there because we could probably keep talking about this for the next hour. There's just so many aspects to it. It's a hugely important issue, and we really hope to start seeing the schools reopening from the beginning of March, like we're being told. But as I've said, if you do have further questions, that relate to individuals, do get in touch with the Children's Rights Alliance, and we'll see what we can do to help you. But also, if you are interested in supporting the campaign, finding out more, we've recorded this session. A couple of people have asked about that, so we will send the recording out to people. We'll make that available, and we'll make any of our information around the campaign available and accessible. I know that we've been tweeting the 2-pager that we have in it already. But thanks so much, everyone, for taking the time out of a very busy day, I'm sure, and hopefully we will start seeing some success. I think the noises are good around children starting to return to school, being prioritised. Unfortunately, we are in challenging times, but the fact that children are being made a priority, I think we should take heart from that. So thanks very much to James and Alan for your time today and for answering as many questions as you could in the time. And please do get in touch if you have any questions or want to get involved in the campaign. Thanks very much.
Thanks very much.